When you are using one of your main witnesses as to whether or not he saw something, it's not good to put something up on a display and then he says that he can't see it. Along with that, it's not good to mention being colorblind. But before we get into that, I am covering day 29 of the Karen Reed case. Welcome to the Roundup, True Crime with Mike. Here I give you update to current cases so you can quickly catch up on cases and legal issues. Views and opinions expressed are my own, and this is not legal advice. The first witness today was the continuation of the medical examiner from yesterday, and I want to show a key exchange that she had with the defense attorney Little.
Regarding a number of injuries that you referred to as blunt impact injuries, correct?
Yes.
And to be clear, blunt impact injuries are a very, very large category that includes contusions, lacerations, abrasions, and fractures.
Correct.
And you've testified similarly that a blunt object can also refer to a large range of objects. Is that right?
Correct.
And I think yesterday you gave the example of a microphone being a blunt object.
Correct.
It could also include something like a baseball bat,
Correct.
a dumbbell,
Could be.
the ground,
Yes.
or a German Shepherd's claws.
Clause. Possibly, yes.
You'd agree that John O'Keefe had a number of blunt impact injuries on his face, on his head, and his right arm.
Yes.
Besides his right arm, which we'll discuss in a second, taking his body from the neck down, he did not have any significant injuries.
From the neck down. Not significant, no.
I think this was the best cross of the trial for the defense for a couple of reasons. One, that Miss Little wasn't overly aggressive and in a manner that people could stand. And second, the medical examiner would not pinpoint anything down as the cause of death, in that it could be anything. She wouldn't rule out anything and paused a little bit but when she was asked if it could be a car. On the autopsy declaration, she ruled the manner of death as undetermined. The interesting thing is that both sides believe it's a homicide. It's just a matter of who did it, unless you want to say it's a dog attack. Lily finished up redirect and the state rested. Right after the state rested, Jackson got up to start his motion, and Judge Beverly asked for a recess and then a sidebar. In what could be described as a mini close for both sides, Jackson asked for a directed verdict, was saying that the medical examiner's opinion in her hemming and hawing on her testimony would show that no juror would convict Reed on any of the charges. It's interesting that he didn't ask for a murder charge to be dropped, but all charges. Lally gave his rebuttal, and in about 2 seconds, Judge Beverly gave her motion denied and asked the defense to start their case. The first witness was Brian Lofgren. We first hear how he knows that he knows the Alberts and other people in town. We find out that he is the plow driver that was responsible for plowing Fairview Road that morning. He talks about getting to his plow at the city area around 2:30 and heading out. Then he talks out his route. And then we get to Unetti putting a map on the screen, and here is what we get.
Regarding a number of
That's, okay. You see that's Fairview Road? Are you able to read that right?
I'm not, to be honest with you. I'm sorry.
Do you still have that map in front of you?
Maybe that'll help you, Mr. Wall.
And actually, can I orient it so it's oriented just like that for him? Okay, that's how it's up on the screen.
Okay.
And by the way, I should have asked this, but is it in terms of is it you can't read the writing or you can't really see the outline of the streets?
Both.
Okay.
So he can't read the writing. Later in his testimony, he says that he is colorblind. Considering that John's shirt was gray and the snow was white, could even tell the difference between the two. He then goes on to say that when he came back later to plow the road again, he saw a Ford Edge in front of the Alberts' house. We learned earlier that Brian Higgins had a Ford Edge. There are questions about times and the routes. Normally, someone parking where they do is supposed to be called in, but Lofgren says he didn't because it was the Alberts and he wanted to be nice. On cross, Lally talks about a report and testimony that Lofgren gave where he stated that his route started at 11:30 instead of 2:30. There is no mention when this report was. Loughran says he doesn't remember those times. Lally then asks if there was something else that happened that night. Loughran says he hit a basketball hoop on his route that he had to report. So here we have a witness that doesn't have good vision, colorblind, hit something else, and didn't see a body that may have already had a few inches of snow on it. The next witness was Dr. Russell. She was a former cop who got a medical degree, and then for like 20 minutes, we hear all the places that she worked. She worked out of the trauma unit in LA and said it was really busy. Then we got to what she is testifying to. She is there to say that the marks on John's arms are dog bites. On cross, Lally went after several items. One, he asked why there was no DNA, and she said that because there was clothing in the way. And Lally asked, why did you know that the clothing was swabbed for dog DNA and there was no dog DNA? He also asked about her paper on dog bites and the limited scope of the dog bites. The next witness was Richard Green. He runs a company called United States Forensics. He has been doing computer forensics since 1996 and has an associate's degree. He was asked to look at the data for 3 phones, John's, Karen's, and Jen's. The first question was from the GPS information. What time did John's phone get to 34 Fairview? And he said 12:24, which aligns with the state's data. From the iHealth data, John's phone shows 87 meters of travel and 3 flights of stairs in between 12:21 and 12:24. Then Unetti and Green bring up the 3 internal clocks on the iPhone and talk about which one the Wazi app uses. Then they talked about Jen's hose long to die in the cold, and his opinion that it was at 2:27 in 40 seconds, and that it was deleted along with some other calls that seemed to be deleted. So a battle of experts. The last thing that was asked by Lally is if he said that he knew Sally Bright released a version to correct the error in this case, and Green said it was for a different version. Sorry it took me extra time to get this episode out. I was playing golf yesterday. Will this be the last weekend that Karen is free? Will she party like it is? Or will they find her not guilty and she will have free weekends in the future? The defense has said that they will call 3 witnesses on Monday and then rest. Closing arguments may be on Tuesday and deliberations starting after that. Everybody will have their own opinion on what the jury should do. Thank you for listening to an episode of The Roundup. Be safe out there, and remember, don't do anything bad that will end up on one of my episodes.